Thank you so much for the very kind introduction. I'm very pleased for you to be having me. So thank you to everyone, especially to Vesna and her team, of course. My topic is, as you have already mentioned, the effect of enforceability. And this is thanks for giving me that topic, because maybe contrary to first impressions, the concept of enforceability is quite a complex one, I think. It's a central concept of general procedural theory, and it's used as well in civil procedural theory, and it's used in administrative law, and it's used in tax law terminology as well. But that's not all. The meaning is iridescent and ambiguous, I think. At least in Austrian terminology, the enforceability can be referred to a claim. Then one speaks of an enforceable claim, which is the case in many provisions in Austrian law. These provisions address the enforceability of the claim itself, which may or may not be accompanied by the enforceability of a corresponding title. The enforceability of a claim must not be confused, this is important, with the so-called enforcement claim, which is the public law claim of an individual to enforcement. In most cases, however, enforceability is used to describe the procedural component, namely the enforceability of a title. So enforceability in this case describes a substantial decision-making effect. It consists in the fact that the owner of a claim can demand enforcement by state enforcement authorities. Enforceability in this procedural sense can only be granted to titles which, by their content, are directed towards a performance. Therefore, only performance orders contained in granting or maybe officially issued performance titles are enforceable. In the case of declaratory and constitutive decisions, as well as in the case of dismissal of a request for performance, however, enforcement, and thus also enforceability as such, is only conceivable to the extent that it concerns an order regarding procedural costs included in the decision. Sometimes, however, the term enforceability is used in a very, very broad sense. It then includes, as a generic term, also other or maybe all legal effects of a decision. This can even comprise legal effects of declaratory and constitutive decisions, as well as of decisions by which claims are rejected. And this leads me to, well, let's say some kind of subtlety. So to say, the term enforceability in a broader sense is used in German law, hi Christian, in connection with provisional enforceability. So let me point out at this very moment that our law, Austrian law, in principle has not implemented the concept of provisional enforceability. There is only one exception, which concerns certain decisions in labor law cases. But in general, instead of a provisional enforceability in Austrian law, there are certain provisions which, under certain conditions, allow a creditor who is not yet able to carry out enforcement leading to satisfaction to carry out the so-called security enforcement. In Austrian enforcement law, the term enforceability occurs in several contexts, whereby the lack of enforceability as a decision effect evokes different legal consequences in each case. And we have two subgroups, so two categories of enforceability. So the subgroups can be divided into the so-called formal enforceability and the so-called substantive enforceability. So I will talk about that now. As regards formal enforceability, the courts or authorities have to confirm that a title cannot be challenged by a legal remedy that inhibits enforceability and that the time limit for performance has expired. So these two elements are important here. If these elements can be confirmed, a title is formally enforceable in the sense of paragraph 1 of our enforcement code, Exekutionsordnung. The confirmation of formal enforceability must generally be made by means of a so-called confirmation of enforceability. In German, it would be Vollstreckbarkeitsbestätigung or Vollstreckbarkeitsklausel. The Austrian confirmation of enforceability, Vollstreckbarkeitsbestätigung, is sometimes also referred to as enforceability clause. So please let me point out at this moment that our confirmation of enforceability must not be equated with the enforcement clause under German law. Because in the context of the Austrian enforceability confirmation, only the formal prerequisites just described are checked, but not the other substantive requirements for enforcement. This applies above all to the occurrence of a condition, to the time limit, and to legal succession. In Austria, the examination of such requirements takes place at a later stage, namely within the so-called proceeding to obtain an enforcement order. In German, it would be Bewilligungsverfahren. The enforcement order is the act by which the court authorizes the enforcement. Only on the basis of this authorization may the actual enforcement proceeding as such take place. Thus, the Austrian law of enforcement is based on a completely different system than the German law is. So this shows once again that despite, or perhaps just because of the supposedly identical language, one has to be truly careful with terms and definitions. In this context, at least, an adoption of the German terminology would be extremely misleading, so I think it has to be avoided. As a matter of principle, in Austria, every enforcement title must be accompanied by a confirmation of enforceability. There is only an exception for certain titles, for settlements, for enforceable notarial acts, and for decisions determining the enforcement costs. For these titles, no confirmation of enforceability is required. The confirmation of enforceability is issued by the authority that has created the enforcement title, the so-called title authority. The issuance of the confirmation, therefore, does not belong to the enforcement proceedings, as does any revocation, by the way, but it belongs to the respective judgment proceeding. And it's governed by the provisions applicable to these proceedings, for example, the Code of Civil Procedure, ZPO. This is important, for example, with regard to the obligation to consult a lawyer, to the costs, or to the admissibility of novation. Well, as far as judicial titles are concerned, the issuing of the confirmation of enforceability falls within the scope of activity of judicial offices, Rechtspfleger in German. The confirmation of enforceability is issued without hearing the opponent. If the application to issue a confirmation of enforceability is rejected, the applying party can file a legal remedy called recurs, which is the legal remedy against court resolutions under Austrian law. In the case of arbitral rewards, that might interest you as well, the chairman or, if he's prevented from doing so, another arbitrator must confirm the validity and enforceability of the award. Next slide, please. Could I ask you to, yes, thank you so much. The confirmation of enforceability is a binding testimony that there is formal enforceability. According to the Austrian prevailing opinion, all courts are bound by the confirmation of enforceability. As a result, there is no need for the court of enforcement to ask whether the title is actually formally enforceable. And this, I think this is quite important. This is the only function of the Austrian confirmation of enforceability. All other conditions for enforcement are, as I have already mentioned, checked later, namely during the proceeding to obtain an enforcement order. Where a confirmation of enforceability is required, it is an absolute prerequisite for enforcement according to the prevailing Austrian opinion. Its deficiency renders enforcement inadmissible. If no confirmation of enforceability is attached to the application for an enforcement order, the court must return the application and give an order to rectify the application. If this order for rectification remains unsuccessful, the application must be rejected. If, on the other hand, enforcement is granted, although there is no confirmation of enforceability, the party against whom enforcement is sought can file a legal remedy, a recourse again, against the enforcement order. If finally a confirmation of enforceability has been issued in an incorrect way, for example, because the title has not entered into legal effect for lack of proper service, the unlawfully issued confirmation of enforceability must be revoked, which is something that has to be done by the title authority again. So let me switch to the other category, to substantive enforceability. And please, could you be so kind as to switch to the next slide? Thank you so much. So in contrast to the formal enforceability just discussed, the term substantive enforceability is used to describe the requirements that must be met in order for an enforcement order to be objectively lawful. Seen in this slide, also the formal enforceability of the title, but not its confirmation, is a partial aspect of substantive enforceability. I think I should mention one thing, that is the fact that the requirements of substantive enforceability are not identical with the requirements that must be asserted and proven and subsequently reviewed by the court in the context of an application for an enforcement order. This is true in particular for negative facts. Negative facts that are mentioned in the title need neither be asserted nor proven. They are therefore not to be reviewed in the authorization procedure. This applies, for example, to the assertion that the other party did not pay, or in the case of a cassatory clause, that the deadline was missed. Nevertheless, such facts do constitute a part of substantive enforceability. Next slide, please. Thank you. So I shall give you an overview now over some of the most important substantive requirements of enforcement. So when we speak about substantive enforcement or enforceability, we refer to the following requirements. First of all, the order for performance must meet the substantive requirements of a valid enforcement title. This concerns especially the parties, so they must be clearly identifiable from the title, and but a correction is would be permissible, but it would lead too far to explain that right now. And the second point is the title must be sufficiently defined in terms of content. That concerns the object, the type, the scope, and the time of the owed performance, and so on. The next point is the claim securitized in the title must in principle be due. In principle, because we have some exceptions. The main exception concerns claims to recurring benefits with maintenance character. Another point, if the applying party must make an advance payment, according to the title, substantive enforceability is only given when the advance payment has been made. If the enforceability of the claim securitized in the title is dependent on a condition precedent, this condition must have been met, otherwise substantive enforceability would not be given. Finally, substantive enforceability includes the absence of a waiver of enforcement or of a stay of enforcement. The fact that this, as a negative fact again, need neither be asserted nor proven in the procedure is, as I have already mentioned, irrelevant in this respect. Well, where the requirements of substantive enforceability must be presented and reviewed by the court, their deficiency must lead to a rejection of the application for an enforcement order, meaning that such an order must not be issued. If the court has overlooked the absence of these requirements and yet issued an enforcement order, the party against whom enforcement is sought can file a recourse against the enforcement order, sensibly combined with an application for a postponement of the proceedings. Furthermore, according to the prevailing opinion, the party against whom enforcement is sought can also file a special action, a so-called action for cessation on the grounds of impugnment. In German, it would be Impugnationsklage, a very complicated term. And in addition to that, the party could apply for a postponement of the proceeding again. Finally, where the requirements of substantive enforceability need not be presented and reviewed by the court, deficiencies can in any case be asserted by way of this special action, the action for cessation on the grounds of impugnment. Well, next slide, please. Thank you so much. Thank you. I will not be bothering you much more, because this is my. And finally, I would like to address a topic that concerns the very core of our project. And this is the question whether the effect of enforceability is also subject to recognition. The background to this question is the following. According to the traditional regime of international civil procedure law, namely according to the Brussels I regulation before its recast, the effect of enforceability is not transferred to another state by mere recognition. Instead, it has to be granted constitutively and originally in a declaration procedure, as you know that, with a sovereign decision. So according to the prevailing opinion, prior to the recast, the levels of recognition on the one hand and enforceability on the other hand were to be strictly separated. Nowadays, however, we have to deal with the wake of the abolition of exequatur and with the new version of Article 39 of the Brussels 1A regulation, according to which decisions are enforceable in other member states without any declaration of enforceability being required. You all know that, of course. So since then, there has been an increasing number of voices that want to depart from the traditional dogma of separation. I mentioned Geimer here because he was one of who said that. So Geimer, for example, speaks of a recognition of enforceability in the sense of an extension of effect, especially since the scope of enforceability is not determined previously the case, but by the law of the first state. So my dear colleague Philipp Anzenberger and I also take this view, meanwhile. And I tell you why. If recognition is to be understood as the import of decision effects, and if enforceability is no longer granted separately by an act of sovereignty, but automatically extended to all other member states by means of Article 39, and to assume that the effect of enforceability is now also subject to recognition. And we think this is supported by the fact that the grounds for a refusal of recognition and the grounds for a refusal of enforcement are identical in terms of content. Well, certainly it's true that the grounds for a refusal of recognition and of enforcement are to be asserted in a different way. But in our opinion, this is not a viable argument against harmonization, because these differences only concern the different procedural handling of the effects of the decision, but they. Well, having said that, I do admit that this is definitely something to argue about. So I will end my presentation now, and leave you room to argue if you wish to do so. Thank you very much.